On my right is Howie Halleck. On his immediate right is Glenn Payne. On his immediate right is Mark Goldfish. And at the end is Arthur Brown.
We talked about what constitutes an investment advisor under Section 2A20. Before I go on to talk about the procedure for approving advisory contracts, are there any questions as to the definition of an investment advisor under the Investment Company Act? Okay.
There's a question.
Oh, I'm sorry.
Glenn, it's been mentioned in this series of lectures that you have more and more funds operating in a limited partnership form. What would be your reaction to a fund operating in a limited partnership form where the general partner is providing some advisory services but claims that it's essentially a director, which is excluded under the definition of investment advisor in 2A20? And therefore the requirements of Section 15 would not apply to them.
Well,
I think that would be consistent with the policy of the definition and Section 15.
the question that has been raised is when an investment company is organized as a limited partnership, and as I understand the question, the investment advisor or a party that would be alleged to be the investment advisor is a limited or general partner, whether that would affect the definition of that entity as investment advisor under Section 2A20. Have I stated the question?
Right.
Okay. As a matter of fact, those limited partnerships that have been organized under the Investment Company Act, typically the entity providing investment advisory services does take the position as partner. They take the position as what they call non-managing general partner. Now, I won't go into all the reasons why it's non-managing. Simply to say that simply because the investment advisor is a nominal general partner does not change the fact that he is an investment advisor to that investment company under Section 2A20. The reason being, he is providing advisory services. He is providing all of the services that a advisor to a corporate investment company provides, and that therefore, if we took any other position, it would defeat the purpose of 2A20, so as to force that conduct of that advisor to be governed by Section 15. So to answer your question, Paul, the situation has come up, and we do take the position that it is covered by 2A20, and as a matter of fact, it's my understanding that there is no dispute as to that fact from the industry or any other party for that matter.
It wouldn't be, in an ordinary situation, a corporate form. It wouldn't make any difference if the investment advisor could sit on the board, could be also an officer of the investment company. As a matter of fact, that is usually what happens. Normally, investment advisors do take a corporate form, but it is not unusual for the president of the investment advisor to be the president of the funds, and at the same time, or to be chairman of the board, and there's nothing wrong. He would be an interested member of the board. But we have taken, in those limited partnership cases, as Glenn points out, the staff they were all allowed to do it by application. The staff did not object for the investment advisor to be the general partner, for the simple reason that when you were looking for who should bear the liability, in most instances, the general partner was the person with the deep pocket. And so we weren't going to protect the fund by depriving it of a source of damages if that should occur.
I think the statute, also the exclusion in 2A20, also refers to a person who is a bona fide director as being excluded from the definition of investment advisor. And it seems to me if a general partner is performing essentially investment advisory services, then he should not be permitted to take advantage of the director exclusion.
Also, in that exclusion, what it's talking about is a director solely on the basis of his being a director should not be considered an investment advisor. If you look at the definition, you will see that because of the exclusion where a person does it for cost, that if a person is being paid a compensation on which he's going to make a profit, in addition to his duties as a director, he would be nevertheless an investment advisor in spite of the fact that he's a director.
Are there any other questions under 2A20? Okay, moving along then, once we have established the investment advisory relationship, the issue then comes as to how the contract then is submitted under Section 15A. The initial question, of course, is when we're talking about a newly organized investment company, how that newly organized investment company fulfills the requirements of 15A4. Given the fact that a newly organized investment company cannot sell its shares or even solicit interest until such time as it has an effective prospectus, and the effective prospectus will describe the terms of the advisory contract, we get into a chicken and an egg problem. You cannot obviously submit a contract for approval of shareholders until you have shareholders, but you have to be able to describe an advisory contract in the initial prospectus. Now, to deal with this problem, the staff initially required, as an undertaking to the 1933 Act registration statement, which of course constituted the prospectus, that the investment company would hold a meeting of their shareholders within 180 days of the effective date of the registration statement, at which time the advisory contract would be submitted to a vote of the shareholders. In August of 1977, the Commission decided no longer to require that undertaking, and in Securities Act Release number 5854, rather than require this 180-day undertaking, set forth the position that advisory contracts should be submitted to shareholders of newly organized investment companies as quickly as possible, but that as long as the contract was submitted to shareholders within 1 year of the commencement of the offering, that would be considered reasonable time for submission of the contract. So now we're talking basically about a maximum of 1 year from the date of commencement of the offering till the date that an initial contract has to be submitted to a vote of a newly organized investment company shareholders. As was noted earlier, given the fact that we have a great deal of potential for conflict where an investment advisor presents a contract to an investment company's shareholders and directors, which then is approved, Section 15, in addition to dealing with the initial approval of such contracts, also sets forth vote requirements for continuation of advisory contracts. Again, the requirement for continuation is that after the first 2 years, a contract must be annually approved either by a majority of the directors or a majority of the shareholders. The issue came up as to what the procedure should be to effect a continuation. Now, the problem was that the question of continuation of an advisory contract was being presented to shareholders 6-7 months prior to the date of termination. And the staff was very concerned that if the question of continuation of an advisory contract was approved, too far in advance of the date of termination of the initial contract, that all of the relevant factors that should go into determining whether or not, in fact, that advisor should continue to provide advisory services would not be taken into consideration either by the investment company directors or the investment company shareholders. There also was a problem whereby some companies found themselves in a position of not being able to know sufficient time in advance to schedule a meeting so that the 2-year period ran out prior to the time that they had submitted to the shareholders or the directors the question of continuing the advisory contract. To try to deal with both of these problems, the Commission promulgated Rule 15A2. Under Rule 15A2, and I should stress before I get into it that this is a so-called safe harbor rule. It provides guidelines for a vote of a continuation of an advisory contract, but it is intentionally phrased as a safe harbor guideline. Compliance with 15A2, strictly speaking, when you read the rule, is not mandatory. However, with the promulgation of the rule, most investment companies, in fact all that I'm aware of, are using the guidelines set forth as in 15A2 to govern approval of their advisory contracts. Under that rule, the first vote to continue the advisory contract after the initial 2-year period will be deemed to be valid as long as the vote takes place during 90 days prior to and including A, the termination date specified in the contract, or B, the second anniversary date of the execution of the contract. So in other words, to deal with the problem of early approval, we now have a general 90-day rule. For subsequent continuations, approval must be obtained in order to meet the safe harbor provisions during 90 days prior to and including the first anniversary of the date of the most recent previous vote to continue the contract. And with promulgation of 15A2, this seems to have solved the problem of questions arising as to what the timing of votes to continue an investment advisory contract, how those votes should be affected. Are there any questions on either 15A2 or what the procedure should be for initially approving an advisory contract? Okay. Another major question that has come up under Section 15A deals with the provisions of Section 15A4. You remember the fourth specific requirement that must be contained in an advisory contract is that that contract must terminate in the event of an assignment. The concept of assignment is a very, very complex one, and a number of interpretive and regulatory questions over the years the division has had to deal with. First of all, the definition of assignment is contained in Section 2A4 of the 1940 Act and provides that any direct or indirect transfer or hypothecation of a contract or chosen action or of a controlling block of the assignor's outstanding voting securities shall constitute an assignment. Now, before I go on, let me simply note that the definition in 2A4 does not include as an assignment of a partnership interest incidental to the death or withdrawal of a majority of the partnership interest or to the admission of a majority partner.
I think that's minority.
I'm sorry. Minority partner. The reason why this was put in to the section is that these changes of a partnership interest were not deemed to involve a substantive change in the ultimate control of the individual in question's policies. And therefore, since they would not deal with a transfer of control of an investment advisor, if you will, there was no need to make that action constitute an assignment. However, taken together, Sections 2A4 and Section 15A4 result in any change of control of an investment advisor or one of an upstream control persons of that investment advisor automatically terminating any advisory contract that exists between such advisor and an investment company. Now, perhaps this concept will become clearer if I could cite to you some examples of transactions that have given rise to an assignment. An assignment and, as I say, the consequent termination of an existing advisory agreement may result from a business reorganization, a merger, a consolidation, a death of a controlling shareholder, or a change in control, as we talked about in an earlier session, of a controlling person of an investment advisor. Now, for example, if Company A is the investment advisor and Company A engages in a merger or a consolidation transaction with one or more new companies and in effect becomes Company B, then, because the ultimate control of Company A by virtue of the merger transaction has changed, this will be an assignment under 2A9, and by virtue of Section 15A4 will operate as an assignment. Now, that gives you some indication of the types of transactions that can give rise to this issue. As I indicated, a number of questions have faced the division over the years. One of the issues that we've had to face, and it came up most often in the no action context, that is, a company would submit to us a fact situation and we would be asked to take a no action position, involved where one of the transactions, most often a business reorganization, involved only an organizational change in the structure of an investment advisor. It did not involve a change in either the actual control or the management of the advisor. An example, you change the state of incorporation, or you go from a partnership form to a corporate form. And that's all that occurs. The same people are in the officer positions and the day-to-day decision-making positions of your investment advisor after the reorganization is effected as were there prior to the reorganization being effected. In those transactions, we have taken and issued no action letters saying that we would not object and would not recommend action to the Commission if such transactions were effected and the investment company continued that investment advisor as their investment advisor without submitting a new advisory contract to a vote of shareholders. Now, these no action positions have recently been codified in proposed Rule 2A6. Now, that is, you can see that in Investment Company Act Release 10809. That's dated August 6, 1979. And you'll see the release inviting comments on that proposal indicates that the rationale for this position is that transactions which do not involve a change in either the actual control or the management of an investment advisor would not contain any of the abusive elements which Congress would have considered to be trafficking in investment advisory or underwriting contracts. Again, that's what was designed to be covered by the prohibition of 15A4. That's why 15A4 was put into the statute, to prevent an investment company from entering into contract with investment advisor A, and investment advisor A undergoing a complete reorganization and becoming a new contract, an investment company finding it's entered into a contract with a new company. Where you don't have that actual change of control, you don't have the abuse. Therefore, we said that we would not require 15A4 termination. That position now has been taken over in a new proposed rule, 2A6.
Glenn?
There is an interesting situation that poses an anomaly to what Glenn has just said. A few years ago, Allegheny Corporation was being contested by two groups. One of them was the Kirby Group, and the other one was the Young Group of the old New York Central. And Allegheny Corporation had control of IDS, an investment advisor, and the the Young Group had the control, and the Kirby Group, through proxy fights and the like, some tender offers, attempted and did successfully wrest control away from Young. Thereupon, someone brought an action to declare that the IDS contracts with the IDS funds had terminated by assignment. And the court held that no assignment took place simply because no change of a controlling block was made. It did not recognize the fact that the controlling person of the controlling person had changed. It stayed strictly to the statute, and one of the elements, the essential elements, is an assignment of a controlling block of stock, and it found that there was no controlling block of stock, and hence no assignment. It comes out to just the opposite conclusion that Glenn has indicated, but for different reasons. And I would think that this was an exception, but this is the way the court held, and the Court of Appeals, as I recall, concurred.
In describing the motivation for 15A4, the legislative intent, it brings to mind a separate question that I know has come up in the no action context. I wonder if anyone knew what our current position was. But the situation, at least there are two general fact patterns. One where a partnership is the investment advisor, as many of the security houses were until pretty recently, and it switches to a corporate form, as Glenn mentioned before. And the partnership, with its liability, might have had millions of dollars of liability and essentially could have capitalized with $1,000, which is really the only thing an investor might be able to get if the advisor breaches its duty. Similarly, although maybe a little less troublesome from the point of view of protecting investors, an advisor is incorporated in New York, subject to New York corporate law generally, finds out that the Delaware statute or some other statute takes a much more lenient position, for example, on the issue of what a prudent investment is, and would perhaps make a difference in terms of whether they were liable for buying Penn Central paper, as happened recently, or some other investment that they made. They switched their state of incorporation.
So, excuse me, is this they're switching the incorporation of the investment company or the advisor?
Of the advisor.
Well, it seems that the test that you would use of whether it was a prudent investment would be they would apply the law of the state of incorporation of the investment company.
Well, I think the question that is being asked is, does this constitute an assignment? Does this constitute a different advisor?
I believe, Arthur, that, as I understand it, those types of transactions that you've described would be covered by Rule 2A6, provided that in either going from the partnership to the corporation or in the change of the state of incorporation, that there was no changes to be made in, as I was describing before, the essential personnel that was control of the management of each entity. Now, I think the factors that you described in terms of perhaps one form or one state law might be more or less liberal would be factors that would be important for consideration by the directors and or the shareholders under Section 15C, which we'll cover in a minute, in voting to continue or not continue an investment advisory relationship with that advisor after the transaction is effected. But as to your specific question, unless I'm corrected to the contrary, I believe we would take the position that that would be covered by Rule 2A6, and therefore we would not view that as an assignment which would cause automatic termination of the existing advisory contract.
Right.
Mark, you worked on proposed Rule 2A6.
Right. The legislative history is fairly clear on this. What was happening prior to 1940 Act legislation was people were founding investment companies. Investment advisors would aggregate the assets, and that in itself has a certain business value, and they would sell that so that somebody who came into the Dreyfus Fund, and as Sidney stated earlier, there's a very strong theory that people do investment companies, as the Commission said in the Stedman case, are merely the brand name of the investment advisor services. So people who would go into a particular fund would then have the assets sold to another management company. And that was the concern that 15A4 was directed to, rather than any judgment of, say, difference in quality of state law, which I would be very surprised if a federal statute would ever take recognition of.
Well, let's pursue the question, Mark, and possibly 2A6 didn't address this. I can't recall, but let's take the other part of Arthur's two-pronged question. The investment advisor moves from a partnership where each of the partners, as you know, has liability. Unlimited liability, and let's assume there is a rich partner, a very rich partner, and they change to a corporation, which in effect conceivably insulates that rich partner from indirect liability.
Right.
Now, I think Arthur's question has the tone of asking, isn't this a different animal?
The Act, nowhere that I'm familiar with, ever looks for a deep pocket in an investment advisor. There's a requirement in Section 14A, for example, that a investment company have $100,000 to make their initial offering, but there is no financial integrity requirements for investment advisors.
Isn't this why I said so?
So your answer is that 2A6 as proposed does not recognize such a situation as being any different. Right.
It's at least it was, I think, the feeling, if the Commission considered this particular question, that if there was a purpose of establishing some kind of financial integrity standard, the Commission, the Act would have established it in a more direct manner than they did.
Yeah. That's why I said, Sid, it seems to me this is a factor that should properly be considered in determining whether or not that advisor should continue to provide advisory services. But I would agree with Mark. I don't think it would be a factor that should automatically cause termination of an existing advisory contract. Reggie, did you have a point?
Yes. In light of Art's question, I was wondering perhaps if we face this type of situation, could we proceed against the new incorporation under Section 36? Perhaps it's the limited partners that went in looking to the general partner in case there had been some type of fraud that might have occurred, and then the general partner later incorporates the partnership to a corporation. Perhaps there might be some Section 36 liability.
The question that has been raised is, under Arthur's question, as to whether or not a change from a partnership to a corporate form to prevent personal liability of one of the partners might be viewed as a transaction which would give liability under Section 36. Well, again, I understand that Section 36 is going to be one of the sections that is going to be covered in these sessions later on, so I hesitate to get into the whole issue of Section 36. The point I would raise, Reggie, I think you raise a good point, and if the facts of the case were to demonstrate that this change occurred for the sole purpose of protecting the individual from being held personally liable, when he had reason to believe that he might well be held personally liable, I would think, applying, as I say, the standards of 36, which I don't want to get into because I don't think we have the time at this session, I would think very well you might have a 36
I would also
liability.
I concur exactly in what Glenn has said. In addition, it would seem to me for the directors of the fund under 15C to allow this to happen without objecting would, I think, bring them within the doubtful area of 36. In other words, you have here Glenn hasn't gotten to it yet, but when you get to 15C, there's a procedure here which shouldn't be just a matter of form. And the question of 36 would probably be focused on what the directors did in that situation to absolve the investment advisor, if you will, from liability.
Let me just supplement that one small bit, because it's interesting. The investment companies that are operating as partnerships are the only examples that I know of where we've required a deep pocket, other than the statutory requirement of Section 14A, and that's because such limited partnership investment companies are basically square pegs that have been pushed into round holes, and there is a possibility, although it's not a definitive possibility, but we couldn't assure ourselves that there wouldn't be a risk to limited partnership investors who are investing as limited partners and who are fulfilling the voting requirements of the Investment Company Act, that they wouldn't be held as general partners because they're taking part in the management. And because of that, we have required a deep pocket. And these people are operating pursuant to orders granted by the Commission, and there is an undertaking that they would maintain a certain amount of financial responsibility in what has been known on the street as the $1 million partner, because it later turned out most of these were subject to a $100 million offering exemption, and we required them to hold 1% in a general partner. And if somebody did that, we would, I'm sure, move to pull their order.
I think, again, to amplify what Mark says, as far as I know, in the proxy statements that are used for shareholders to approve a contract, I don't think the net worth of the partner is a requirement to be disclosed. The net worth of each partner of the investment advisor. So conceivably, one could say that when the advisor was approved by shareholders, he was approved without regard to the specific net worth of any partner, and therefore the fact that that wasn't a consideration in the voting, the question comes up: why now should it be a consideration with respect to an assignment?
Well, Sid, just without prolonging the discussion much longer, I would say that in the original prospectus, at least the advisor, its place of incorporation or organization, and its background is often disclosed. It's often a major selling feature. So I think at least an argument could be made the other way, that somebody was relying that this calls for a special review by the board or by the shareholders.
Yeah,
the board review, of course, as Glenn points out, is always a possibility, and I think they should, at a time of change of incorporation, consider it directly. One other point, and maybe it comes out clear in the Advisors Act of 1940, which has somewhat a comparable provision for assignments. When you have an advisory contract with a client, you can't assign that contract. You particularly think of the smaller advisor or the guy who's a wealthy, upstanding member of the community, gets some local citizens to give him their money with discretion, and he then incorporates, rather than being a sole proprietor, he becomes a corporation, and his $1 million net assets may, depending on the state law in the particular case, be insulated in case he does violate 206, for example.
Well, 2A6, of course, only has to do with investment advisors of investment companies, and in the situation you refer to, I think becomes a question under 206 of the Advisors Act, the anti-fraud, whether this person has a duty to disclose the different types of liability. See, under the present new ADV, a balance sheet is required, and so that where that balance sheet materially changes, a disclosure would seem to me might be appropriate regardless of the assignment. I think that to those who are making inspections, when they have any change in the investment advisor that seems to change the liability of that advisor, and it hasn't been disclosed in any public documents, I would suggest that the inspector consult his supervisors or the appropriate people in the division about it.
Yeah. Just one additional point on this item, and we're taking some time on it because it is, as I say, a question that interpretive and regulatory questions have come up quite often, and it's an area that both on an inspection as well as in home office personnel might be called upon to determine whether or not an assignment is involved. An example of, Sid made reference to the IDS Allegheny situation, an example of where there was a transaction that we would term involving no actual change of control, and thereby it would be a candidate for Rule 2A6 if Rule 2A6 ultimately is adopted. I suggest you take a look at Investment Company Act Release 10649, dated March 26, 1979. That is a notice of an application that has been submitted by Investors Diversified Services, Inc. and Allegheny Corporation on behalf of their investment companies, which involved a situation where Investors Diversified Services, Inc. is the investment advisor to all of the companies. It was proposed to be merged into a new subsidiary of Allegheny Corporation. Allegheny Corporation already held 60% of the voting securities of IDS, and therefore they were simply going from a 60% to 100% interest. You'll see in the notice of the application statements that the management was not going to change, the key officers were going to remain the same, and this is a prime example of a type of transaction that we're talking about, that if 2A6 is adopted, we would no longer take the position that that constitutes an assignment. Now, in those situations, however, where there is an actual change of control, under 15A4, there is no alternative but to immediately terminate the investment advisory contract. Well, the issue has come up as to what do you do in a situation where it is impossible or impractical for an investment company to have a shareholders meeting for purposes of approving a new advisory contract prior to the time that the transaction occurs that constitutes the change of control and then the automatic termination of the investment advisory contract under Section 15A4. Again, the prime example of this is what happens when an individual who holds a controlling interest in an investment advisor, which again, more than 25% of the voting securities, dies. And his shares then are transferred according to will or according to state law. Now, the death and the subsequent transfer of the shares will constitute an assignment. But we do not want to be in a position of, because of the existence of 15A4, unilaterally depriving that investment company for a period of time necessary to submit a new advisory contract to shareholders from receiving any investment advisory services. To deal with that problem, the division in the past granted a series of exemptions, temporary exemptions, from the provisions of Section 15A4 to allow investment companies that found themselves in a position of assignments occurring prior to the time of submission of new advisory contracts to their shareholders. Now, it is to be emphasized that this exemptive relief was temporary exemptive relief, and it has been extremely limited. One of the limitations is that it is limited as to time. That is to say, such exemptive relief should not run for more than 90 days, except in the most extreme cases. That is to say, we will not give companies more than 90 days to effect the process of submission of new contracts to their shareholders. And the second limitation, the major limitation, is that, again, these applications, for the most part, dealt with situations where the assignment was not within the control of either the investment company or the investment advisor. The unexpected assignment, if I can use that term. And where it applied to a situation where not to give the relief would involve a unilateral step that would prevent the investment company from receiving any investment advisory services. Now, the positions that have been taken on these applications have been now codified in proposed Rule 15A4. Now, the terms of that rule and the rationale and conditions are also set forth in Investment Company Act Release 10809. And if you're on an inspection, or if you're asked a question as to what the position of the staff is in terms of giving relief from 15A4, the standards are set forth in 10809, and if 15A4 ultimately is adopted, that will be the standard that will be applied by the division. Does anybody have any questions on this assignment area before we move on?
Could I just say something sort of the inverse of the rules? If an inspection, or it comes to your attention that an investment advisor has entered into one of these transactions where they're merging in with another corporation or anything else, and where it's going to get an economic benefit, and it's not a transaction under Section 15F, which Glenn will talk about in a minute, but if somebody just assigns the contract and does it for his own benefit, and leaves the investment company holding the bag with all the expenses inherent in calling shareholders meeting and getting the new contract ratified, then I think we have a real question under Section 36, and I think that's the type of thing that the Commission would be willing to take action on.
I agree.
I don't think there's any question about that. Okay? In addition to the requirements of 15A, both in terms of the specific provisions that have to appear in investment company advisory contracts and the requirement of initial shareholder approval of new contracts and either shareholder approval or director approval of continuance of existing contracts, Section 15C sets forth procedures that have to be followed in either the approval of new advisory contracts or continuance of existing advisory contracts. And the requirement is simply that in addition to the 15A requirements, that an advisory contract has to be approved by a vote of a majority of the disinterested directors of the investment company cast in person at a meeting called for that purpose. Here is where I made reference before when I began my remarks on 15A. The section attempts to ensure that there is an independent review of the terms of the advisory contract to ensure that the advisory contract is in the best interests of the investment company shareholders. Here is where we try to deal with the conflict of interest that Sid talked about the last tape, where the investment advisor presents to the investment company the question of whether it wants to enter into a contract with that advisor. We rely on, under 15C, the independent directors, the disinterested directors, to make their own review of the terms of the contract. And specifically, 15C imposes two duties on the disinterested directors. The first is a duty of the directors to request and evaluate such information as may be reasonably necessary to evaluate the terms of the contract. In other words, the directors have to request sufficient information in order to allow them to make an informed judgment as to the value of that contract. They cannot simply approve it at the request of the advisor, or they cannot simply approve it at a pro forma meeting of the board of directors. This 15C contemplates some type of intensive review by the disinterested directors of the terms of advisory contracts prior to their exercise of their approval or disapproval under 15C.
The commission has recently, within the last 2 months of this taping, taken action against two groups of so-called independent directors, in which in neither case did they receive any materials upon the renewal of a contract. And in both cases, in one case, approved the contract even when it wasn't on the agenda for the meeting of the board of directors meeting, and improved an increase. They did this in less than 10 minutes of discussion with apparently no prior information, because, as I say, it wasn't even on the agenda. In the second case, even though it might have been on the agenda, no materials were given to the disinterested directors, and again, they approved the increase in the fee, a new contract, without any discussion at all. We had early in the inspection process of this division, we had a case which was almost ludicrous. The investment advisory agreement had been renewed year after year, and when our New York office went in and asked where the meeting was held, they found that the meeting was held in the middle of a restaurant at lunch, with all kinds of people in adjoining tables eating, and they were conducting a board meeting while they were eating lunch. And when we asked what was discussed, they told us the thing that was discussed the most at the meeting was Army's chances over Navy next Saturday. The meeting was held always a day or two before the Army-Navy game. The commission authorized us to charge 36. At that time, Section 36 said was phrased in that a director would be guilty of gross misconduct and gross abuse of trust. We had on that board a Presbyterian bishop of the Philadelphia diocese, and he was going to be charged with gross misconduct and gross abuse of trust. Hardly something that was palatable. We had a general that was an instructor at West Point on there, and we had other people of equal importance. We settled that case without ever bringing them. Needless to say, those directors did not remain on the board, and as a matter of fact, those directors took an undertaking never to be a director of an investment company again. As far as I know, they haven't been. But I just wanted to say that there have been a period of time when these contracts were approved in an extremely cavalier way, and if the inspection program did anything, it forced the directors at least to have the opportunity to look at the data in which they could make an informed judgment as to whether or not to renew or to enter into an advisory contract.
And it is the Section 15C duty that both at the inspection level and also when questions come up in Washington, that the staff uses to encourage thorough consideration by boards of directors of investment companies of the terms of advisory contracts. And particularly, as we'll cover later, with more and more authority and discretion being given to the independent directors. As an accompanying factor there, we are expecting the independent directors, particularly in their review of advisory contracts, to bring the independent, probing, questioning of the investment advisor and the other insiders that really was what was hoped and expected that they would bring to investment company boards of directors. So when you hear and see the commission and the division talking about the duties of directors of investment companies to thoroughly evaluate and review investment company contracts with their advisors, it is this duty under Section 15C that we rest that analysis on. I might simply say quickly that there is a second duty in 15C, and it poses a duty on the investment advisor to furnish the information requested by the disinterested directors. I think this is fairly self-evident. It wouldn't do very well to give the directors authority to request information, or indeed not just the authority, but put the duty on them to evaluate information to allow a thorough consideration of investment advisory contracts if there was not a procedure whereby they could obtain the information. This procedure simply is the investment advisor must furnish all of the information that the directors need in order to make a thorough consideration of the advisory contract. Is there any question?
Glenn, I have a question. Maybe it'll just serve to clarify or expand some of your remarks. 15C and 15A were both changed in 1970. I mean, there was even the change to get directors to attend in person
That's very
these
important.
meetings, and that there had to be a legislative change for that, is sort of telling about some of the shortcomings of the investment company advisory contract negotiation and consideration. And there were instances of telephone hookups
Yes.
or seriatim calls, which were perfunctory. And
In order to get the majority of the independent directors, they contacted a person on a safari in Africa, and asked, and he voted by telephone from Africa, which the staff particularly didn't appreciate. It was instances of that sort that brought this type of legislation, that the meeting had to be called for the purpose of reviewing the contract, and it had to be voted on in person by those persons voting. One other little item: when they say a majority of the disinterested directors, it means just that, not a majority of the disinterested directors that attend the meeting. In other words, if there are two disinterested directors, a majority of two disinterested directors is two. And those people have to be there. If one of them isn't there, the contract cannot be approved.
I would also say in 15C, and this I think is a pretty difficult section. We've talked about, and Glenn's particularly mentioned, the thorough review and the independent review of the advisory contract. But I must say that 15C, as amended, tells the directors, directs them to review this in person carefully. It tells the advisor to bring whatever material they ask for to the meeting and provide it to the directors. But when you're in an inspection, or when, for other reasons, you're reviewing what action the directors have taken in this regard, you are then in the position of having to consider what constitutes a thorough examination. And when you're thinking about an advisory contract, what are the key things? And what are the key things from the perspective of the investment company? Investment performance, the amount of the fee, the willingness of the advisor's demeanor towards the board, and if he's providing other administrative and managerial services, how he's performed those, whether there have been shareholder problems. 15C avoids laying out what they should consider, because it is very hard. Those things are all obvious, I think. I think those things should all be part of the record. But then there are a lot of other things that may be important. When there's an increased fee, and an increased fee is something we've seen a lot of in the last year or two. What does it take to justify a change from the typical 0.5% advisory fee, 0.5% of the net assets, to 0.6%? What does it matter to the investment company? Does the advisor have to show that he's losing money? Or does he have to show that he can do better advice if he gets more money? Does he have to show that it's competitively reasonable? And I think it's a very troublesome area. I think I don't mean at all to suggest that 15C should be rewritten in a more specific way, but I think you have to recognize we've now directed the directors to consider everything thoroughly. Presumably they'll do it, but there's a lot of questions of judgment probably best left to them in many respects. But on view of the total facts, particularly in an inspection, although it comes up in the application process in our shop, to really look at those papers to see if there's a fee increase, that there's some justification for it, that there's some analysis of the performance, and that really is, that's what shareholders are in there for. They're for an advisor who's beating the market or beating comparable funds. They're not looking for somebody who does the worst every year. And paying him anything for that is a real trouble.
That's an important point, Arthur.
There, we'll have to wrap it up now, and we'll start again in a few minutes with the new tape.